Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions on any aspect of English law. On this show, I should be able to cover most English legal matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to contact us on the two numbers that appear at the bottom of the screen. If you want to speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. Alternatively, another popular way of getting in touch is to send me a message, a text message or a WhatsApp message on the mobile number that also appears at the bottom of the screen. So a live call through to me here in the studio. In order to do that, you just need to call on the landline number, and messages you can send through on the WhatsApp number. The mobile number, very popular with our viewers. A lot of people don't necessarily want to come on live on air because their issues are sometimes confidential. And therefore, it's an easy, quick way of getting in touch with us, simply to send us a message on the mobile number. Couple of very minor points before we get going and start dealing with the questions that have already started coming in. First of all, sometimes when callers call in, the matters are quite complex. We need to take very detailed information from viewers who call in. Now, if it transpires that your matter is complex, then I will ask you to leave your number with the control room, and then I will give you a ring after the show's finished, and I will have a more thorough discussion with you off air. That's for very difficult, complex matters. Similarly, secondly, if I need to look at your documents before I advise you, for example, it might be an immigration matter where you've received a refusal letter or you've received a letter from solicitors, etc., and you want advice on that document, then again, I'll ask you to leave your number with the control room and I will have a discussion with you after I've seen the document off air. So if it's complex or I need to look at documents, more than happy to discuss the matter with you off air. And again, the advice that we provide is part of the free legal advice show, and it's not something that you will be charged for at all. So rest assured, you can speak to me live on air, send your messages on for more complex matters. I'm more than happy to have a discussion with you off air, even if you need a second opinion on a matter that's currently being dealt with by existing legal representatives. Now, as always, even before we've come on the show today, we've had a number of WhatsApp messages that have started coming in. So what I propose to do is let me start dealing with those questions that have come in. But as always, you can give me a ring live on air, or alternatively, as I've said a couple of times before, please do feel free to send your messages in. Okay, we get a number of immigration questions on WhatsApp, which is fantastic. Let's look at one of the first questions that we've had for today. Now, let me read the question out. Our viewer says, I have a sister. She is married. Her husband is in the United Kingdom. So we've got the sponsor here in the United Kingdom, married to the sister who's abroad. She was married before the husband came to the United Kingdom. The question is, if her husband wants to sponsor her to come to the United Kingdom, does she need to do the English test? Some people are saying she doesn't need to do the test, and she only has to do it after her husband gets settlement in the United Kingdom. Okay, question has a number of different issues in there. So, husband is in the United Kingdom. It appears to be the case that the husband doesn't have indefinite leave to remain in the United Kingdom. The wife is abroad wanting to come to the UK. Now, what you need to look at is the question about whether the spouse who's abroad who wants to come to the UK, whether that person needs to do a test or not, depends actually on the immigration category under which the wife will be coming to the UK. So you don't simply look at the fact that, oh, there's a husband here and the wife is going to join the husband and therefore there must be an English test. No, that's not the case. You look at the category under which the wife is coming to the United Kingdom. And the reason I say that is, For certain categories, there is no requirement to do an English test. For other categories, there is a requirement to do the English test. So don't look at the fact that a wife is joining a husband, or the other way around, a husband is joining a wife. Don't look at the fact that these are partners who are joining each other in the United Kingdom in order to work out whether the English test is a requirement or not. Look at the category under which the partner is coming to the United Kingdom. So let me give an example. And I think, although we don't have enough information here, I think this is the scenario. Let me give you an example. Let's say the husband in the United Kingdom is here on a skilled worker visa, what used to be called Tier 2 or work permit. So he's here on a work visa. Now, if the husband here is on a work visa and he was to sponsor the wife to come over as a dependent of his, as a dependent of somebody who is on a work visa in the United Kingdom, then there is no English language requirement at all, because that category doesn't have an English language requirement. There are various factors that which need to be demonstrated, but English is not one. However, contrast that with a normal spouse visa, a UK national living here, somebody settled living here who is not here under a work category, simply settled here, has indefinite leave to remain. That person wants to sponsor the wife to come to the UK. That's a normal spouse visa for which the English language requirement applies. So the starting point is look at the category under which the person is applying to determine whether the English language requirement applies or not. Now, there are more detailed rules about the English language requirement, which I will address shortly. But the starting point always is look at the category first. Okay, we've had a number of messages which have been coming in. Let's look at those. So just before the break, I was looking at the question relating to the English language requirement, and what I was advising was whether or not there is an English language requirement or not really depends on the category under which somebody is applying. So if somebody is coming to the United Kingdom on a spouse visa, they will have to meet the English language requirement. If they're coming to the UK on a non-spouse visa, such as a work permit, or what's now known as a skilled worker visa, they're coming to the UK as the dependent of a skilled worker, they won't need to meet the English language requirement. But if there is an English language requirement that needs to be satisfied, what is it? What is this English language requirement? Look, the position again is this: you have to look at the immigration category that the person is applying under. Generally speaking, for spouses, the requirement is that they need to pass a test at A1 level, which is the most basic type of English test that you would need to pass. So that's the kind of requirement that applies for somebody who's coming to the UK as a spouse. Once they're in the UK and they extend their visa, they apply for indefinite leave to remain later on, the English requirement gets tougher. So at the extension stage, it's an A2 test. At the indefinite leave to remain stage, it's a B1 test. So as you progress, as far as spouse visas are concerned, the tests become more difficult. Now, in the example I gave earlier, if somebody is coming to the United Kingdom to live with somebody who's here on a work visa, so a dependent of a skilled worker, initially there is no English language requirement. At the extension stage, there is no English language requirement. It's only at the indefinite stage, after they've lived in the UK, there is a requirement to pass the B1 test in English. So every category potentially has a different type of English language requirement if it applies. Now, contrast that with somebody who's coming to the UK under one of the work categories, or they're coming to the UK as a student, or they're coming to the UK as a sole representative or a business person. All those different categories will have an English language requirement at different levels. So you do really need to look at, when you're looking at the English language requirement, you do need to look at what the category is before you can work out what the level of English is that is required. Hope that answers the question. Let's look at the next question that's come in. Now, question again relates to immigration law. The question is this: my son got married in March 2021. He's a student and still has 3 years left at university. What do you advise in terms of how he's able to sponsor his wife to come to the UK? In terms of the wife, she works as a teaching assistant, I'm assuming, abroad. And the person here in the United Kingdom is self-employed. What's the easiest way of sponsoring the wife to come to the United Kingdom? And it's a brother from Nottingham who's sent that question in. So again, it's a spouse visa, but the circumstances are slightly unusual. Unusual in the sense that the sponsor in the United Kingdom is not in employment, which is typically what you have. They normally are in employment or self-employment. Here, the issue really is that the sponsor in the United Kingdom is a university student, and it appears to be the case that the person also has some type of self-employment income. The issue here really is this, that if the son who is in the United Kingdom wants to sponsor his wife, the financial requirement will apply. And it's really a question of how the financial requirement will be satisfied. Now, in a normal situation, the financial requirement is that the sponsor in the United Kingdom needs to be earning £18,600 per annum. Now, we're going to be taking a short break. After we come back, I'll look at what the actual English requirement is, if it applies. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. Alternatively, to send me a message, a WhatsApp message with your legal question, you can do that on the mobile number which also appears at the bottom of the screen. And you demonstrate that by either employed income or self-employed income. Self-employed income is income over the financial year, whether it's April to April or if it's a business operated through a limited company, it's the income received during the financial year of the company. But the starting point is the income requirement is £18,600. And that has to be demonstrated even for a student. So there's no exception here. The student, the sponsor who's a student still has to demonstrate an income of £18,600 per annum. So that still has to be done. The question really is, what kind of income will the student show? Now, here we've got a situation where the student, the sponsor, does have some income through self-employment. The only flexibility that we have here is that in addition to self-employed income, it may be possible to show other types of income, including a student grant, a maintenance grant. So that may be something that can be added on to the income. So for example, if somebody's income is, let's say 14,000 per annum, so they're receiving 13,000, 14,000 pounds per annum, but in addition to that, they receive a grant, and the grant can make up the shortfall to take them up to the 18,600 mark. That's something that can be done. So a student sometimes is in difficulty because they're full-time students, they don't have sufficient income. But one way of meeting any shortfall is to see whether any student grants that they get can be added to their normal income to make it up to £18,600. So if you go down the normal spouse route, the problem or the issue is simply going to be, how is the financial requirement going to be met? A particular problem because students may not necessarily be working full time. So that's really the issue. Now, sometimes what you then do is, if that's going to present a problem, sometimes what you're forced to do is look at the situation outside the normal spouse route. So is there another way of the wife coming to the United Kingdom? So not as a spouse, is there another way of coming to the United Kingdom? For example, is it possible for the wife to come to the United Kingdom on a student visa? So if it's somebody who wants to study, has studied, it may be that that's a way of coming to the United Kingdom. Downside to a student visa normally is the expense. Typically, 1 year at a university, whether it's or on an undergraduate degree or a postgraduate degree, the yearly fees for a student visa are in the region of around £14,000. But that is an option. Somebody could come to the UK as a visitor, potentially later on, then switch into a spouse visa if it's easier at that stage. So one is the student route. Another could be that if they're qualified, if there's a business in the UK that's willing to sponsor them under the skilled worker route, they could potentially come to the UK under the skilled worker route as opposed to the spouse route. So in these situations where there may be some difficulties in meeting the financial requirement, you are then forced to look at alternative ways of coming to the United Kingdom. I mean, in my experience, where you have these slightly tricky situations, from a practical point of view, it's always easier to try and meet the requirements of the spouse visa route and try and come to the UK as a spouse. I know we've discussed here the difficulty with finances, but you're probably better, and it's probably cheaper and more practical to somehow try and meet the financial requirement, as opposed to looking elsewhere, looking at the student route, looking at the skilled worker route, because those are expensive, difficult routes in themselves. So it's better simply, in my experience, to focus on the spouse visa route and to see how the financial requirement can be met. It may be that it can't be met straight away. The student may have to wait so that they're able to work during their summer holidays. When they have 3 to 4 months off, they can work then and earn the money that needs to be earned in order to make a successful application. For example, somebody might take on work over the summer period and then that carries on. You look at the average income over 6 months, and if that gets to 9,300, you might be able to meet the requirements at that stage. So in practical terms, you try and meet the financial requirement initially. It's only if that doesn't work that you look outside the financial, the spouse visa route and look at other routes of coming to the United Kingdom. Hope that answers the question. As always, if you want to speak to me live, you can give me a ring on the landline number which appears at the bottom of the screen. Alternatively, by all means, do continue to send your messages in like you have been doing, and I've been trying to address them live on air. Now, next question that's come in, slightly different question to do with inheritance. And we do actually get some questions on wills and probate and inheritance. Let me read the question out and then look at what the potential solution to that is. Question is, my nan is the homeowner. If something was to happen to her, she was to pass away, who would have the legal right to sell and manage the property? She has a will where she has divided the property equally between her 7 children. So the question is, grandmother is a homeowner. If something was to happen to her, if she was to pass away, who has the legal right to sell and manage the property? She's got a will where she's divided the property equally between 7 children. Okay, so question regarding probate. Now, if somebody has made a will, what normally happens is the will actually deals with two things. The will deal with how the estate of the deceased is to be divided. So here we're told that there is a house and it's to be divided equally between 7 children. So that's one matter, one important matter that the will deals with in terms of what's going to happen to the house, what's going to happen to the deceased person's estate. So that's obviously what the will primarily covers. But in addition to that, a properly drafted will explain whose responsibility it will be to carry out the wishes of the deceased person. So there will be normally 2 people appointed under the will to deal with the estate. And it's those 2 people who have the responsibility to deal with the estate, which may mean actually selling the property if that's what the will provides for. Basically carrying out the deceased person's wishes. They are carried out by the people appointed under the will. So they are different sometimes to those who will actually inherit. There may be an overlap, there may not be. Just let me give an example. Sometimes what you find is that in this situation, the grandmother may want to leave somebody who she feels is more responsible. So it might be quite an elderly person, it might be a professional person in the family, etc., who they feel would be able to deal with their assets. So they are given the responsibility to deal with selling the property, dividing the assets, distributing the money. But actually the people who inherit are the actual family members, and here it is the 7 children. So starting point is look at the will. The will explain whose responsibility it is, who has been appointed to deal with the estate. Now, that's where a will has been left, like the scenario we have here. The situation in which there is no will, then the situation is slightly different. You look at normally who inherits the deceased's estate, so who gets the money of the deceased, and it's those people who inherit. They would normally apply to the probate registry for permission to deal with the estate. It's whoever gets the application in first with the strongest right to deal with the estate. So that's what happens when there is no will. But here, in answer to your question, there is a will. A properly drafted will deal with whose responsibility it is to deal with the estate. So hope that answers your question relating to the responsibility for the estate and making sure that the estate is divided in accordance with the grandmother's wishes upon her death. Hope that answers the question. Right, we've had a number of messages coming in on WhatsApp, so I'll crack on with that. But by all means, please do feel free to pick up the phone if you've got any questions that you need clarification on. Okay, the next question that's come in relates to a family law and also relates to immigration. I think there's a slight overlap. Let me read the question out, then let's look at what the issues are and what's the most practical advice that we can give. Message is, Assalamu alaikum, marriage took place and was registered in Pakistan. That's fine. The wife is a Pakistani national. The husband here in the United Kingdom is a British national. The marriage was never registered in the United Kingdom. And it's the husband who's the British national who is saying that he wants to divorce her since she, as in the wife, doesn't want to live with him. And he goes on to say, give more details about the problem with the marriage. So the pertinent circumstances here are that the marriage actually took place abroad in Pakistan. Wife is a Pakistan national. The husband who is seeking legal advice is a British national, and the marriage is not registered in the UK, only registered abroad in Pakistan. Now, common question that we have, which is, whether there is a need for a formal divorce or not. A lot of different issues arise in such a situation. Maybe the best way to explain it is this. We're going to be taking a short break. We'll be back in the next couple of minutes. We've had a number of questions coming in, and I'll deal with those questions after we come back from our break. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, to send me a message, a WhatsApp message, you can do that on the mobile number which also appears at the bottom of the screen. So, telephone call to speak to me live on air, that's on the landline number, and messages can be sent through to me on the mobile number. The starting point always is you assess whether the marriage that's been entered into is recognized as a legal marriage or not. That's always the first question, because that then determines how that marriage is brought to an end. What are the steps that you need to take? So, starting point, is the marriage a legal marriage under English law? Is it recognized as a legal marriage under English law? Now, an Islamic marriage in Pakistan is recognized as a valid marriage in the United Kingdom. So there's no need for that marriage that's taken place in Pakistan to be registered here in the UK for it to be valid. The fact that it was a proper marriage in Pakistan, an Islamic marriage is a proper marriage in Pakistan, the fact that a proper marriage took place in Pakistan in accordance with Pakistani law means that it is recognized in the United Kingdom as a valid marriage. There are very limited exceptions to that, which we hardly come across. There may be issues about proxy marriage, there might be issues about second marriage, but those are very, very limited exceptions. So if there's an issue about proxy marriage, there's an issue about second marriages, you may need to take further advice. But in 99% of cases, where it's a standard marriage, if I can call it that, in Pakistan, under the procedure that you have in Pakistan, that marriage is recognized in the United Kingdom without any further steps having to be taken. So there's no need to have a civil marriage in the United Kingdom. There's no need to register it anywhere with the embassy or anything. The fact that you've got married abroad automatically, in most cases, will automatically mean that the marriage is recognized as a valid marriage in the United Kingdom. Now, the reason I say that the starting point is look at the validity of the marriage, it's because if the marriage is a legally recognized marriage in the UK, then the marriage has to be brought to an end properly for it to be recognized. It's important. It's important for a number of reasons that the marriage is brought to an end properly. And I'll look at how that's done after I've taken the next call. Hello, Assalamu alaikum. Hello,
Assalamu alaikum, brother.
Ji walaikum salam, Ji bhai. Thank you for calling.
How are you, brother? You okay?
Alhamdulillah, good. How are you? You okay?
Yeah, I'm good, brother. Thank you. Actually, I do have a hearing in a couple of days.
Okay.
Yeah, so my question is the judge tell you on that day that your case going to be successful, or is he going to send you the decision? So
okay, right. In the vast majority of cases, the judge won't give you a decision straight away. The judge will normally say to you, you will get a written decision within 2 to 3 weeks. That's what the judge normally says. Now, what kind of appeal do you have, which is before the tribunal? What kind of case do you have?
Is asylum appeal asylum case?
I understand. Now, in asylum cases, they are complex cases. It's highly, highly unlikely that you will get a decision on the day. Most of these cases, you get a decision in 2 to 3 weeks. Now, what could happen is, depending on how the hearing goes, you might get a good idea, or your lawyer might have a good idea as to whether the appeal is going to be successful or not. So you might have a good idea whether it's going to be successful or not. But in my experience, you won't get a decision on the day. It will take 2 to 3 weeks to get a decision. You normally get it, your lawyer will get the decision by email in about 2 to 3 weeks after the hearing.
Yeah, your voice is cutting, but I don't know why. But I couldn't hear you properly.
Sorry, so what I was explaining is normally you will get a decision in 2 to 3 weeks after the hearing. So you will get a decision in writing 2 to 3 weeks later. The judge won't give you a decision on the day normally.
Okay, thank you. Just one more question. Basically, I'm from Afghanistan, and the situation in Afghanistan, is not good right now. Is that can benefit? That can give me any benefit?
Sorry, which country are you from? I didn't quite catch that.
Afghanistan.
Because you're from Afghanistan.
Yeah.
If it is established or if it is accepted you're from Afghanistan, your application will be successful. Your appeal will be successful. Okay,
but they do accept that before the Home Office accept that I'm from Afghanistan.
That's fine.
And,
If that concession has been made, if the concession has been made that you are an Afghan national, they have to grant you refugee status. It may be that the Home Office will concede your case on the day. They may have to concede the case on the day. Because on the day, if they don't concede it the day before, they may have to concede it on the day of the hearing. Anybody who is from Afghanistan who currently has an appeal going will realistically have their appeal determined in their favor. Anybody who's got an asylum case going on where it is accepted that they are Afghani national will be granted, generally speaking, refugee status. It's very sad what's happening in Afghanistan for a lot of people. But as far as your situation is concerned, because you're an Afghan national, your appeal will succeed. There's no way that it's going to be refused.
Oh, okay. Thank you very much.
No problem at all. And best of luck for your forthcoming hearing.
Okay, thank you very much. Take care.
Take care. You too. Important point about Afghan nationals who are in the United Kingdom. Mainly, two things I should have covered at the outset. One is those who are here and they've got some kind of refugee application either ongoing with the Home Office or they've got appeals ongoing. Realistically, they will be successful if it is accepted that they are Afghan nationals. If the applications have been refused before, you can make fresh submissions now, and that should succeed as well. So that's the situation with Afghan nationals. Let's take our next call. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Wa alaikum salam. Thank you for calling.
Brother, I have a question. It's basically for an auntie of mine. She's had a divorce a few years back. Okay. And there was no financial settlements or anything done, but the divorce did take place. But her and her ex-husband own a property together. But it's on mortgage, obviously. So the mortgage is under both of their names. But now my auntie wants to basically get her share out of the property. Either her ex-husband sells the property or buys her out, or whatever it is that he's doing. So we just wanted to get the right guidance of what type of law or category it comes under. Where what does she need to do?
Okay, the starting point is because the financial aspects of the divorce were never resolved. There's no order in place. There's no consent order. It can be raised at any stage. So aunt here in this situation can make an application. So normally, are there any children involved at all?
There is children involved. Well, at the time of divorce, one was over 18 anyway. And the youngest one, she just turned 16. So she's with the mother, of course, at the moment.
Okay, so there's one child under the age of 16. And the property, I'm assuming, jointly held, is it, at the moment?
Yes, at the moment, yes. But obviously, she doesn't live there because because of it was something related to domestic violence and everything. So she does, she had to leave.
So who lives at that property at the moment?
He's at the property at the moment.
Okay, all right. Now, realistically, it's probably in her interest to try and get this matter resolved before the child turns 18. She is likely to get a bigger share of the assets because the child lives with her. So it's in her interest to get a move on try and get it resolved. Realistically, it looks like the property would have to be sold because the child and the aunt don't live at the property, so there's no reason to keep the property to maintain the status quo because the child doesn't need the property to live there with mum. The child lives elsewhere. So the natural solution here, the normal solution here would be to go for a sale. He can buy aunt out or aunt can buy him out. If that's not possible, it's on the open market to sell. But the normal situation is the sale. Now, it may well be because the child is with the aunt gets a greater share. So it may not be a 50-50 split. It may be a bigger share in favour of the aunt. But the normal situation here is sale of the property. She should make the application now. It's in her interest when things are in her favour to make the application now.
But
she should.
So you would recommend that she does the financial settlement with her ex-husband now, before the young girl turns 18, because
yes, 100%. Yeah, because if the settlement can't be reached, put the application into court. Definitely, it's more advantageous to go now and try and resolve this matter either amicably or through the courts.
Because what she was asking was, should she just go for the property because he's saying that he hasn't got assets and things like that.
Then the property would have to be sold. Just before the break, we had a caller on the line who wanted advice in relation to his aunt's divorce and more particularly relating to the house that she owned with her husband. What happens to the house following the divorce? The divorce took place a few years ago. The financial settlement hasn't taken place. So wanting some advice in terms of what needs to be done. And my advice was to try and deal with the matter now. It might be more advantageous for her whilst she has responsibility for a child under the age of 18. So it makes sense that somebody who's got the children living with them following a divorce, they have a slightly bigger share of the assets when they're divided because they're having to provide for the child who is under the age of 18 as well. Now, we had to take a break, so I wasn't able to address any follow-up questions. But what we were discussing towards the end, just before we took the break, was really in relation to if the ex-husband isn't able to buy out aunt's share of the property. So if one party can't buy the other's share out, then what would happen? What would then happen is that the property would need to be sold, and the court would make an order along those lines that the property will be put up for sale, etc. Both parties will sign the sale documents. If the parties don't comply, let's say here the husband doesn't comply with signing the transfer papers on the property following a sale, we're going to be taking a short break. What I will do is when I come back from the break, I will address this issue in slightly more detail. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, you can send me a message on the mobile number that also appears at the bottom of the screen. If one party is able to buy the other out, fantastic. If not, it would go on the open market. There would be a sale. If one of the parties doesn't sign, there's a procedure for dealing with that in court as well. Final bit of advice, reiterating what I said before the break. To me, it seems like it's more advantageous for the aunt to go now and try and settle the matter now, whether by agreement or through the courts. Hope that answers the question. Now, just before I took the call, I was looking at the validity of a marriage that's taken place in Pakistan. Wife's a Pakistan national. Marriage takes place there. The parties don't register married in the UK. What's the status of the marriage? And I was explaining that bar some very limited exceptions, it's a valid marriage recognised under English law. You don't need to The marriage doesn't have to have been registered under English law. It's a recognized marriage. So a proper marriage, a legal marriage, has to be brought to an end legally. And so in the United Kingdom, simply having an Islamic divorce won't be enough. That will obviously bring your Islamic marriage, the religious marriage, to an end, but it won't bring the civil marriage aspect of it to an end. You will have to go through the family courts here in the United Kingdom. There may be another solution, which is using the formal divorce system in Pakistan for the divorce. So it has to be a proper system in mainland Pakistan. It's the court system that you would have to use. In Azad Kashmir, you use the Tehsil Mufti office to get the divorce. But the point I'm making here is this, that because the marriage is recognized as a valid marriage, in order to bring it to an end, you need a formal divorce. A simple talaq under Islamic law in the United Kingdom won't be enough. And it's important to bring the marriage to an end properly, formally, for a number of reasons. For example, if the parties here want to remarry, formally remarry, obviously Islamically it's possible, but formally remarry, it's not going to be possible. You're not going to be able to register your marriage at a registry office. Another example is the ex-husband here goes abroad, gets married again, wants to, or even the ex-wife goes abroad, gets married abroad, wants to sponsor their partner to come to the United Kingdom. Unless the first marriage has been properly brought to an end, formally brought to an end, it's not going to be able to sponsor somebody from abroad to come to the United Kingdom, because as far as English law is concerned, you're still married. Islamically, you may not be married, but under the eyes of English law, you are still married. There's other issues relating to inheritance, etc. If you're still legally married, your ex-partner under Islamic law would potentially still be able to inherit under English law. So various problems can arise if your marriage is a legally recognized marriage and it hasn't been brought to an end. So certainly you should speak to a family lawyer or an immigration lawyer who has knowledge of these issues relating to marriages which have taken place in different jurisdictions, to make sure that whatever needs to be done is done to bring matters to an end. Hope that answers the question. As always, to give me a ring live on air, you can ring on the landline number, but as always, you can continue to send your messages in on WhatsApp. Let's look at the next question that's come in. Question is, let me read the question out and let's look at it. Again, immigration question, but more to do with business visas, and more to do with operating some kind of business in the UK. So the question is this. My brother, who is living in Dubai, has a business which involves international transactions. He's got a New Zealand nationality. So New Zealand national living in Dubai, has a business which has international transactions. Can he open an office here? First question. How long will it take him to get his family into the UK, settled into the UK? Now, can he open an office here? Opening an office in the United Kingdom isn't necessarily problematic. The question really is there an immigration category that he can come to the United Kingdom under? I think that's the question. So somebody with New Zealand nationality operates a business in Dubai. Can that person come to the United Kingdom on some kind of business visa? I think that's what is being put. And if they're able to come to the United Kingdom on some kind of business visa, can he and his family get settlement in the United Kingdom? All right, so the starting point is really this. What options are available to him? There are only realistically two options open to him. One is coming to the UK under the skilled worker route, the old work permit route. The other is whether he qualifies under the sole representative route. Both routes are potentially open. They're not easy. They have quite extensive requirements which need to be fulfilled. So one is the skilled worker visa route, one is the sole representative route. The skilled worker route wasn't really an option for those who own their own businesses, because previously the skilled worker route, previously known as the Tier 2 general route or the work permit route, only was open to those who might have had a share in the business, but it was limited to 10-20%. I can't remember the percentage now, but they had a real minority stake in the business. They could come to the UK under the work permit route. Anybody who was the real owner of the business couldn't come to the UK under the work permit route. Now that restriction has now been lifted. They can potentially now come to the UK to work for their own business. However, it's not that straightforward. There are certain steps which need to be followed. So the business would need to be established, first of all, in the United Kingdom. And once it's established, it would need employees in the United Kingdom. So once there is an established business in the UK with employees, the business would then have to be registered with the Home Office for a sponsor license. So you would need a sponsor license for that. So that's the starting point. You need a sponsor license for that business. Now, if you manage to obtain a sponsor license for that business, which is the brother's business, similar to the business that's been operated in the Dubai, if you manage to get over all the hurdles, you establish the business here, you get it registered with the Home Office to sponsor migrants from abroad, the brother can potentially come to the UK on that business. So that business can potentially sponsor him to come to the United Kingdom. I suspect that may well be the easiest route for him to come to the United Kingdom. Once he is able to come to the United Kingdom under the work permit route or the skilled worker route, he would be able to sponsor his family to come to the United Kingdom as well, his wife and any children under the age of 18. So there is a route there that leads to settlement over time for the whole family. But the starting point is identifying the route. The route, in my view, is coming to the UK as a skilled worker. In order to do that, there has to be a business here which is registered with the Home Office, which is able to sponsor migrants, which is able to sponsor the brother to come to the United Kingdom. So that's one potential category. The other category that I mentioned was the sole representative route. There are more complications in my experience. In my experience, the Home Office currently is quite strict with sole representative applications. Sole representative applications can succeed. The problem is you can't use the sole representative route if you're the main owner of the business. That's where the problem is. If you've got a minority stake, you hold a senior position in the business, and then potentially you can use the sole representative route to establish a branch office in the United Kingdom, establish a subsidiary office or whatever it is in the United Kingdom. And what you would be doing as a sole representative is, as a representative of that business that's abroad, you'd be coming to the UK and you would be operating that business in the UK. I think the sole representative visa has difficulties here because you can't use the sole representative visa route when you're the actual owner of the Dubai business. It's not for owners to use. It's for senior employees who want to be based in the UK and who want to run a branch office of that business that's more established abroad. So sole representative may not work. I think the best option may well be to simply look at the skilled worker route. And as I've said, the starting point for that is you need to first of all, do the legwork to establish the business here. You need a plan, you need a timeline, set up an office, get employees employed open your bank account, etc., register it with HMRC, operate your business, then apply for a license, and then use that license to sponsor the brother to come to the United Kingdom. Absolutely legitimate route, 100%, to sponsor somebody to come to the United Kingdom. So that's one of the major changes that came in with the skilled worker route in January of this year. A fundamental change from what we had before. Following Brexit, it's been made slightly easier to employ migrants, and that's one of the routes where you can establish your own business, and the business then sponsors you to come to the UK, along with the fact that it's now the income requirement for somebody who's coming to work here has been lowered. The skill level has been lowered. The resident labour market test, where you had to look for people within the UK first or Europe first, that's been done away with as well. So the skilled worker route does present a real possibility for those who want to come, work, contribute to the United Kingdom. Hope that gives you a thorough answer in relation to that question. Now coming to the end of the show, hopefully we'll be back next week on Tuesday at 8 o'clock. Inshallah, see you then.